Am I audible?
Yes, sir.
Thank you. Good evening, Mr. Singh. Total? Is Ruchi there? Hello, Ruchi.
Yes, sir, she is here. She'll answer in a second.
Okay. And is Ruchi coordinating the program?
Yes, sir.
Okay, wonderful. Ruchi, you're coordinating the program?
Yes, I was actually looking at the technical things. So my video and audio was off.
Yeah, no problem at all. We'll start at about 5, right?
Yes, yes.
Good evening, Colin.
Good evening.
Ajay here.
Good evening, sir. How are you? Nice.
We heard you last year, I think, on the Human Rights Day, PCGT.
It's wonderful that we can keep in touch like this, isn't it?
That's one of the advantages of the online mode. I'll just rename myself so that.
Ruchi, I'll do my thing at 5, no?
So 5:10, there is some welcome and introduction.
Yeah, no problem at all. There's an audit going on, so I have to be with you.
Okay, sir.
But I'm happy to be here. Thank you for inviting me.
Mr. Singh, I think you are on mute, sir.
Where is Mr. M.N. Singh?
Sir, he's here, but sir is on mute.
Okay. There you are. You're still on mute. We can't hear you, Mr. Singh.
No, sir, still on mute. Yes, sir, now you're unmuted. Still can't hear you, sir.
I think some issue with the microphone and not muting.
Sir, I think it would help to leave the meeting and rejoin again. Sometimes when this problem occurs. Sir, I'm suggesting that you leave the meeting and join again. It helps sometimes.
Your ma'am has also joined. Good evening, ma'am.
Am I audible?
Yes.
Okay. Hello, everyone. I'm texting Principal Ma'am. She'll be joining soon.
Okay.
Am I audible? Ruchi ma'am?
Yes, you're audible.
Okay, fine.
Hello.
Good evening, sir.
Good evening, Mr. Ribeiro.
Good evening, Raja.
Good evening, sir.
I'm still looking for Mr. Eman Singh.
Where is he?
Came, it was not.
So there was some problem with the voice thing on his device. I'm coordinating with him.
Problem with what?
Something on his device. Some I don't understand the technical this with something on his device.
Hina ma'am.
Immense sir. Nathan sir.
म्यूट करू कसं
Mute.
नको ना
मी काय बोलणार नाही म्यूट करता येतं
Good evening, ma'am. Good evening, sir.
Good evening, Ruchi.
Good
All
evening,
set for the
sir.
program?
Yes, thank you so much, Prasad sir, for joining.
Good evening, Mr. Prasad Chandran.
Good evening, Mr. Raja. Look forward to the program.
Good evening, everybody.
Good evening, Anna.
I'm also looking forward. I've heard Mr. Colin Gonsalves speak before and really looking forward to hearing him again. Of course, Mr. Raja and
Good evening, Anna.
good evening, Mr. Raja.
What are you wearing over your neck, Anna? That's what are they? You know, at a certain angle, it looked like a schoolgirl with, you know, two beads, that kind of thing.
Good evening, Julia. Good to see you.
Hi, Prasad.
Good evening to all.
Good evening, ma'am.
Good evening, ma'am. Good evening, Dr. Smita Vaidya. Nice to meeting you. I'm VP Raja.
Because of some technical reason, I'm not getting.
No, we are able to hear you and see you.
The moment laptop will be okay.
Good evening, madam.
Hello, Mr. Singh. Is the voice issue clear now?
Am I audible?
Yes, sir,
Yes,
you
sir,
are.
you are.
Okay, thank you. Thank you.
Mr. Aman Singh appears logged in the list of participants.
Show me that letter, Bodhi. That letter that he sent.
Oh, there you are.
Hello, Principal ma'am. Have you joined?
Yes, I am here.
Okay, ma'am.
Yeah.
I believe we are good to go.
All other guests are here.
Yes, ma'am.
Sweetly, we did the work.
Welcome, Mr. Aman Singh. You can hear us?
Yes.
And to
We can proceed with no issue. The moment laptop.
You need to persist. Yeah. Deer and Deer Dolakia, these are also good form. Dua Associates is also good form. To be long, mujhe pata. Okay, so
Himanshu made
Music.
Kritika ma'am,
Yes, ma'am. Yes, ma'am. I'm here.
audio looks to be not clear. We see that.
There must be some network issue, ma'am.
My audio is okay, na?
Pithawala sir is also here with us.
Acha, welcome, sir.
Good evening, sir.
Good evening, sir.
Aman, you can hear us?
Sir.
Well, I can hear you, but I can't see you.
Oh, I am there, sir.
I can hear you, but I can't see all of you.
No, that depends on which view you are in.
You know, no, because see, on my laptop, I could see all of you people. You were not able to hear me. So now I am on my iPhone. So
okay, we can go ahead, I think.
Yeah. So
I think you should start.
My computer guy is working on it. In the meanwhile, we start on this iPhone. Though I'm not able to see any one of you, but
we can see you and hear you.
Oh, very good. Then go ahead.
Sir, there is a problem. Your video has been pinned. If you unpin your video, you can see the others.
The video is clear. I mean,
yes. Now you may be able to see others.
Yeah. I can see only one of you. Professor Kurtikat.
Yes, sir. That's me, sir. So whoever will be speaking, that person will be visible. If you could just slide on your right, you can see the other participants on phone.
Okay, go ahead. Let's start.
I think you have to go on the gallery view. If you go on the gallery view on the top right hand corner, then you will be able to see all the people.
He's on mobile, sir. That's.
I'm on the mobile.
Oh.
Hello, Pitawala sir. Nice to hear you, sir, after a long time.
Yes,
This is
yes.
Aswar,
Nice
sir.
to meet. Nice to meet all of you. I'm very happy to be with you and looking forward to today's session.
Yeah, sir. Now it's, we could see your face, sir.
Thank you.
After a long time, sir. We are always missing you, sir.
Thank you. And also glad to meet the principal.
Yeah.
Whom I have not been able to meet personally because of these COVID restrictions. How are you keeping, madam?
Pleasure welcoming you, Professor Pitawala. I am VP Raja from PCGT. What you inaugurated is going on very well. The Constitution.
Well, I'm very happy to
program.
hear that. Very, very happy to hear that. And I think Ruchi has put in a lot of effort.
Yes, she's.
Which I think we must all appreciate, Mr. Raja. Has Mr. Ribeiro also come in?
Yes, he is very much here.
Wonderful. Oh, you're there. Very nice to see you, Mr. Ribeiro.
Thank you.
Good evening, sir. This is Colin. Nice
Hi, Colin.
to see you, sir. Nice to see you.
Hi, Colin. Why don't we start?
Yes, sir. Raja, sir, Principal ma'am, with your permission, should we start?
Yes, we should start.
Sushmita?
Yes. Please. Move it.
Can I start?
Yes.
Yes, please.
Okay. Good evening, one and all. All of us are aware how important freedom of speech is, and we have watched it being taken away from us. To discuss this very same issue, I want to thank Mr. Colin Gonsalves, Mr. M.N. Singh, and VP Raja sir, and all of us joining today as responsible citizens to learn more about this burning issue of detention and free speech. The NSS unit of Government Law College Mumbai, in collaboration with Public Concern for Governance Trust, presents panel discussion under AZADI 75. I, Sushmita Pagar, NSS volunteer, will be the host for the evening. Allow us to begin today's event with Saraswati Vandana.
या कुन्देन्दु तुषारहार धवला या शुभ्रवस्त्रावृता या वीणावरदण्डमण्डितकरा
हे होत नसेल
या श्वेतपद्मासना
वो वाला लाते क्या वो वाला
या ब्रह्माच्युत शङ्कर प्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा.
Before starting our panel discussion, I would like to give a brief introduction of the institutions which are organizing this program. Government Law College Mumbai, with a heritage spanning over a century and a half, has dominated the legal landscape of India since its inception in 1855. This esteemed institution enjoys the distinction of being one of Asia's oldest law colleges. Generations of distinguished legal luminaries who have been nurtured by this unique institution have made a seminal contribution to the evolution of Indian legal system. The college has consistently maintained high standard of education by emphasizing on the extracurricular balance between academics and extracurricular activities. This renowned law institution, Government Law College, Mumbai, is celebrating the 75 years of establishment of the Constituent Assembly of India and the Platinum Jubilee year of Indian independence by organizing 75 different events throughout the academic year 2021-22 in this celebration called AZADI 75. GLC NSS unit under guidance of our beloved program officer, Professor Krutika Tembunikar ma'am, is relentlessly working on the line of the motto, not me, but you. GLC NSS unit has organized organ donation awareness, election awareness, vigilance week, several street plays, session on RTI, fundamental rights, cleanliness, the anti-plastic movement, new labor codes are few examples of the work done by this unit. This panel discussion will be feather on the cap for us. PCGT is a registered trust founded in the year 2002 by Sri J.F. Ribeiro, Dr. R.K. Anand, and the late Sri B.G. Deshmukh, in order to promote transparency and accountability in governance and to inculcate values and enhance Sadbhavana in citizens. Previously, PCGT and Government Law College Mumbai has organized dialogues, workshops, and seminars as requested by the campus ambassadors on issues that are related to good governance and involving eminent speakers and role models in different fields to guide and inspire the youth. I would now like to request the Honorable Principal of the Government Law College Mumbai, Dr. Asmita Vaidya ma'am, to welcome the speakers, guests, and the audience for today's event. Over to you, ma'am.
Thank you, Shusmita. Very good evening to one and all. Ma Saraswati La Vandan. Today, it is a good moment in which both the institutes, GLC and PCGT, they are going together, and the outcome of it is this joint venture with GLC's NSS unit. We have with us as a panelist, respected Advocate Colin Gonsalves, founder HRLN, respected Shri M.N. Singh sir, retired IPS, former Commissioner of Police Mumbai, and Shri V.P. Raja sir, retired IAS, Chairman PCGT, along with all viewers. On behalf of Government Law College, I welcome the panel members as well as all the esteemed guests who are present here today, and all my beloved students. As you all know, preventive detention laws in pre-independence and post-independence era is the subject of today's discussion. Preventive detention is basically detention without trial in order to prevent the person from committing a crime. Preventive detention thus is a special form of imprisonment. A person can be put in jail or custody for two reasons. One is that he has committed a crime, and another is that he is likely to commit crime and create disturbance in the society, or is a direct threat to society and security of the state. Thus has the potential to commit a crime in the future, and therefore good ground for putting him behind the bars to prevent the commission of crime. Preventive detention is also known as necessary evil of the Constitution, as it can be steered in various directions and can be put to use in various situations, which may not be just and reasonable. And therefore, it is the most controversial part of our fundamental rights, we can say. It gives enormous power to the authorities to twist the tool of preventive detention as per their vision will. This has proved to be a way in which freedom of masses has been immensely curbed and continues to be so. Thus, has tendency of getting misused rather than used in a wise way. Friends, India became free in 1947. And this particular act has also been passed in 1950. And under this act, we find that many cases which were actually been put in, like A.K. Gopalan case, wherein the motive was little bit political and not the other. Preventive Detention Act 1950 empowered the government to detain without charge in the name of public safety and security after facing constant criticism of violating fundamental rights. The act lapsed in 1977 and 1976, and another act named Maintenance of Internal Security Act, that is MISA, has came into existence in 1977. MISA was again deleted, and another act that came into existence called TADA. And after TADA in 1987, again it was repealed, and then we got the POTA Act. MISA was deleted in 1978 following the misuse of preventive detention in the infamous emergency situations, we can say, after which National Security Act was also enacted, which remains in force till date. So other acts, as I told you, they were TADA and POTA. There are constitutional safeguards against the preventive detention laws under Article 22 of the Constitution to prevent reckless use of preventive detention. Firstly, a person may be taken to preventive custody only for 3 months in the first instance. Secondly, the detainee is entitled to know the grounds of his detention. And thirdly, the detaining authorities must give detainee earliest opportunity for making representation against the detention. These safeguards are designed to minimize the misuse of preventive detention. It is because of these safeguards that preventive detention, basically a denial of liberty, finds a place on the chapter of fundamental rights. These safeguards are not available to enemy alliance, as we all know. India is one of the few countries in the world whose constitution allows for preventive detention during the peaceful time without safeguards. The constitution expressly allows an individual to be detained without charge or trial for up to 3 months and denies detainees the rights to legal representation, cross-examination, timely or periodic review, access to the courts, or compensation for unlawful arrest or detention. In short, preventive detention as enshrined under Article 22 strikes a devastating blow to personal liberties. It also ruins afoul of international standards. As it has been observed, preventive detention lacks the element of check and balance. A major concern of preventive detention is that it is a very wide provision without any mention of specifications and limitations, which exposes it to a wider context of interpretation, thereby vesting major power in the hands of authority. Hence, this provision in our constitution requires effective and intrinsic study and survey of the root cause and accordingly framing of the appropriate law, which also provide for efficient and necessary check and limitation mechanism to prevent its unjust as well as unconstitutional use in any situation. In the understanding the importance of this subject, we have invited the experts from the field for panel discussion. I hope all will enjoy this academic feast and outcome of the discussion will be taken note of. I again welcome all the panelists, all the experts, legal luminaries who are present here, and all my colleagues as well as my students. With this word, I conclude. Thank you. Over to you, Susmita.
Yes. Thank you, ma'am, for that encouraging address and your kind support to make this event take place. It is now time to introduce today's esteemed panel, starting with Mr. V.P. Raja, sir, who has obtained 2 postgraduate degrees in physics from Delhi University and Columbia University, USA, before joining the Indian Administrative Service in 1974. While in service, he completed a MA in Rural Development Planning from University of East Anglia, UK. He further obtained an MPhil degree in Social Science from the Indian Institute of Public Administration, New Delhi. As an IAS officer of the Maharashtra cadre, he has worked in various assignments at the district, state, and center. In recognition of his outstanding contribution to administrative reforms while working as a collector of Satara and as Transport Commissioner Maharashtra, Mr. Raja was awarded the Distinguished Government Administration Award with the Government of India. He worked at the Ministry of Human Resource Development, the Planning Commission, the Ministry of Defense, and at the Department of Atomic Energy. He retired as Principal Advisor to the Department of Atomic Energy in September 2008. He is currently serving as the Chairman of the Public Concern for Governance Trust, PCGT. Thank you very much, sir, for taking your time out to join us. Now I would like to introduce our next speaker, Mr. M.N. Singh, retired IPS officer. Mr. M.N. Singh obtained his master's degree in physics from Banaras Hindu University before joining the Indian Police Service in 1967. We all are aware about the effective role which Mr. Singh played during the investigative process of the 1993 Mumbai serial bomb blast case as the Joint Commissioner of Police. Later, as Commissioner of Police of Mumbai City, he effectively curbed organized crime and rid the city of the scourge of underworld gangs. Mr. Singh is considered to be an authority on organized crime. He has authored an exhaustive report on growth of organized gangs in Mumbai City, as well as a book on communal violence. At the end of a distinguished career spanning over a period of 35 years, he retired as Director General of Police. So we are really blessed to have you on our panel today. Moving towards our next panelist for today, Advocate Colin Gonsalves. Mr. Colin Gonsalves is the founder of Human Rights Law Network, HRLN, a graduate of the Indian Institute of Technology, Bombay. Mr. Gonsalves started his professional life as a civil engineer, but was drawn into the field of law through his work with the unions in Bombay. He commenced formal legal study in 1979 and litigated his first case. While still in law school, on behalf of 5,000 workers locked out of their jobs. Mr. Gonsalves has written, edited, and co-edited copious number of articles and books on a range of human rights law issues. For such inspiring work, he was presented with the International Human Rights Award by the American Bar Association in 2005. In 2010, he was conferred a doctorate of the University Honoris Causa by the University of Middlesex, UK. He was also given the Mother Teresa Memorial Award for Social Justice in recognition of remarkable contribution in legal services, addressing human rights. In 2010, Dr. Gonsalves was awarded the Right Livelihood Award in 2017. It is an absolute honor to have you present here, sir, today. Now, I would like to invite PCGT Campus Ambassador, Mr. Tanay Musare, who would be the moderator for the panel discussion. Over to you, Tanay.
Thank you very much, Sushmita, for that lively introduction of the guests. Now, without wasting any further moments, I would like to invite the first speaker of our panel discussion, Shri Colin Gonsalves, sir. Respected sir, the topic of today's discussion is preventive detention laws in the pre-independence and post-independence era. In relation with it, we also need to address one of the more troubling issues at hand, the components and the implementation of the clause of sedition and the UAPA Act. To apprise our audience about these two clauses, the clause of sedition contained in the section 124A of the Indian Penal Code mentions the punishment for any acts, whether spoken or written, which incite hatred or violence towards the government. Whereas the Unlawful Activities Prohibition Act, UAPA, is an act formulated to protect the security of the state from any proved or assumed potential threat to defense of India. Speaking of a recent case example, we all are aware that the three youngsters, Natasha Narwal, Devangana Kalita, and Asif Iqbal Tanha from Delhi, were arrested a year ago under the UAPA Act. They were arrested due to their connection with the Delhi riots, which took place the previous year. They had been part of the protests or demonstrations against certain policies and actions of the government. Here, in this case, even if we consider that a protest in which they had participated may have taken a violent turn, even then it would be difficult to assume that the actions caused a threat to the security of the state or to the defense of the country. It could be violation of law and order at the most or other provisions. Since the subject of law and order falls under the state list, the authority to arrest these youngsters under UAPA can be questioned. Under the Preventive Detention Act, it is mandated that the detention period of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. But in the case of UAPA or sedition, the bail process is quite stringent. The accused can be detained for a long time without any bail plea. In recent times, we have seen the case of Father Stan Swami and also the other individuals detained, or even the case of Kerala-based journalist Mr. Siddiq Kappan. Can it be the case that considering the long detention period under the UAPA and sedition clauses, the executive may intentionally be using the power of these provisions to muzzle the free speech and criticism by the masses? What would be your opinion in this matter, sir?
Thank you. Time is limited, and I thought I would focus my brief talk on the latest developments in preventive detention, in which preventive detention law is not used. NSA is not used at all. And the police have come up with innovative means of keeping people in detention for very long periods of time and getting away with it. And it's important that everybody understand and realize what's happening so that they can stand up and protest, as people are protesting in this country, and to make the voice of opposition louder. The old, let's say the NSA laws, for example, you are detained by an order. That order will give you the grounds on the basis of which the order is made. And ultimately, you go before a panel of judges of the High Court. And you can tell the judges that there's no reason why you should have been detained and ask for you to be released. Detention could take its own time. Sometimes you have detention for as long as up to 1 year. But in the end, and I know in those days, 1 year seemed a very long time, but as compared to what is happening today, where you can be in detention for 5, 6, 7 years, it's amazing. And after some time, the judges would say, all right, we release you because we don't believe the grounds of detention are valid enough for you to be kept in detention. Those were the good old days. Those were the bad old days, because preventive detention, as you were told by the previous speaker, is anathemic to the rule of law. That you can be kept in jail without a charge, without credible charges and so on, is something no country in the civilized world or the democratic world will tolerate. But India is the largest democracy in the world, which is very uncivilized as a norm, and very crude and rough and brutal in its treatment of ordinary citizens. So we have come to live with that India, where there's a huge, let's say, gap between the image of India as Mahatma Gandhi and non-violence and the current pictures that you see in the newspapers of extreme violence being inflicted upon people for the mere exercise of democratic rights. I want to talk first about UAPA and tell you how UAPA was used as an instrument of detention unlawful detention, according to me. And then I will end it by talking a little bit about sedition, as the earlier speaker suggested, to show how sedition law, which has no place on the statute in any democratic country, is also used as a very powerful weapon for preventive detention. Now, as you know, UAPA law, and particularly its bail provisions, they were modified to change it from general criminal law. And let me say a few words prior to this. Let me just rewind a little bit. You see, criminal law was meant towards charging a person, generally not arresting him unless that person needed to be arrested to prevent him from running away or committing another crime. A trial which was supposed to be a speedy trial. And in the end, you remained in jail if you were convicted, or you would be acquitted and go scot-free. The police today don't like this system. It's a normal, civilized, constitutionally valid system. The police today don't want this system. They don't want to investigate. Investigate takes time. Investigation takes time and effort. And they want to catch people against whom they have a grouse. People who are speaking up against society's ills, who are speaking up against people in power, who are speaking up against ministers, who are speaking up against corruption. Politicians today, and particularly home ministers across the country, they want to catch these people and put them behind bars. Do they have proof? Well, in many of these cases, the investigating officer himself knows there's no proof really to keep a person behind bars. So you need laws and you need certain practices so that on the basis of your likes and dislikes of a person's vocal cords, very stringently and tenaciously talks against people in power, catch him by his collar and put him in jail. And sustain that jail term for 4 or 5 years, 6 years maybe, endlessly. As you've seen in the Bhima Koregaon case, you've seen in so many cases right across the country. So UPA had a provision which changed the bail, statutory bail requirements, and put in a requirement that the judge must come to the conclusion, prima facie, that the allegation in the charge sheet is prima facie true. So far, so good. But then along came the judiciary, the Supreme Court of India, no less. And in Watali's case in 2019, and if any of you want the exact citations, I can have it sent along. In Watali's case, the Supreme Court did something very cruel. The Supreme Court said that while deciding an application for bail under UAPA, any evidence placed before the court by the prosecution agency, even if that evidence is not admissible during the trial, can be used to argue against bail. And that's an astonishing proposition, but it comes from the Supreme Court, no less, which means that if the evidence that the government is showing the court, you'll see Khalid's case and all these cases, thousands and thousands of pages of charge sheet. But when you come to trial, the trial judge will say, I'm sorry, take away all these papers, none of this is admissible, this is called hearsay evidence, non-admissible evidence. But at the stage of bail, Supreme Court said, take the document as it is. So hearsay evidence and all kinds of other kinds of evidence which is not admissible, the court has to consider and take it as it is. Take, for example, Sudha Bharadwaj's case. Somebody wrote a letter implicating her in something, unsigned letter, not in her handwriting, and she was denied bail on the basis of such a document. Now, if you go for trial, a trial court judge, any normal trial court judge, will say, Mr. Prosecutor, don't waste my time. Throw it away. Don't want to see it. Not admissible. But at bail, he was denied bail. And all the other cases that you see, storytelling, today's investigation agencies have become, like these Harry Potter books, beautiful storytelling. A met B, B said this, C they met D, D did this, he said this, A said this. This is the crime, horrible crime. War against the nation. But if you ask the trial court judge, as I advised in a number of cases, as Khaled is speaking in the papers, you'll read them carefully. Show me a single page which demonstrates on the basis of admissible evidence that I have committed a crime. And the public prosecutor will say, Your Lordship, it's a very complex case. There are 3,000 pages. They bring the documents in wheelbarrows to impress the court as to the volume of the evidence. And all that the judge has to do is to sit back and say, I've got plenty of time, Mr. Prosecutor. You tell me it's a complicated case. I'm willing to sit. Show me the evidence. But judges don't do that. And that's the decline of our criminal jurisprudence in India. Judges say, well, it will take some time. We'll have it on another day and so on. And it goes on and on and on. And of course, now you have in Natasha's case, a brilliant judgment of the Delhi High Court, stunning judgment, where the Delhi High Court did just that. Show me the evidence. In the Guwahati case of Gogoi, show me the evidence. And the high courts are leading the way, not the Supreme Court. The Supreme Court, by and large, has gone along with this government mischief. I mean, they're not conscious of the government mischief, I hope. But they went along with the government in, denying bail. So many people denied bail. Some of our best freedom fighters of the modern era, rotting in jail. And this is a battle, my dear friends, which is akin to the national movement. Because just as once upon a time we had to cleanse Indian politics of the British, clean India of the British, we have come to a stage where a new national movement is needed to clean India of all these kinds of rotten characters who dominate Indian politics, Indian society, Indian life. Anyway, so UAPA provision and this Patali judgment meant judges were afraid to touch bail applications, except for the cases I mentioned now, Gogoi's case and Natasha's case and so on, and a few other cases. And so what happens is, on the basis of fairy tales, now if you can take an unsigned letter, Sudha's case again, unsigned letter, not in my handwriting, not relating to me, implicating me, I heard somebody say something, etc. And the Supreme Court tells the judge, you must take it as it is, then bail gets denied on the basis of storytelling. And your case will start after 4 or 5 years, so that's preventive detention of 5 years, without a single document to establish that you have committed a crime of heinous proportions. This is UAPA, terrorism. Evidence that you made a bomb, evidence that you conspired to distribute AK-47s or whatever latest weaponry they had, nothing. And the crux of the matter, in all these CAA protests, NRC protests, the only weapon used, and it's a very powerful weapon, but it's a lawful weapon, is the power of your mind and tongue to speak against power, speak against those in power. Government didn't like it. CAA, NRC protesters charge sheeted under sedition. Thousands. The Jharkhand tribal said, we don't want anyone coming into our areas. We are declaring this is tribal self-rule. We don't want your Aadhaar card. We don't want your banks. We don't want food from you. We will run our own government. 1,000 against 1,000 tribals, sedition cases filed, an attempt made to have them arrested. So UAPA was the big thing that said, that allowed the courts, and I must say it's shameful. And I do hope there's a turn in the way the courts think, particularly the apex court. And I think it will come, because there are some very fine judges in the Supreme Court. The turn must come. At this bluff of the government, that we have evidence against you of terrorism, but we'll show it to you when? Only at the trial. To which a trial court judge will say, then you come to me at the time of trial, and then I'll put him in jail when I see some evidence. But unless you show me evidence, I will not keep a man in jail for a second. The judges have not had that confidence. Okay, now, there was a second thing now, and that is UAPA also changed the period for the filing of the charge sheet up to 180 days, normally 90 days, 180 days. And there was some confusion that if the prosecution doesn't file its charge sheet in 180 days, say it files it on the 190th day, what happens? Now there's a provision for statutory bail, namely if you don't file it within 180 days, and the accused files an application for statutory bail on the 181st day, then the police wake up and file the charge sheet on the 182nd day. There was some confusion as to whether the person would get statutory bail or not. And there have been brilliant recent judgments. I must tell you, the judiciary has done something amazing in Bikramjit Singh's case, where the Supreme Court, relying on previous judgments, Uday and so on, said, once the accused files the application for statutory bail, subsequent filing of the charge sheet by the prosecution will not take away that right, indefeasible right to bail. So you have to be alert, quickly file it on the 181st day, and you must get bail. And Bikramjit was one judgment recently, and yesterday, day before yesterday, another bench of the Supreme Court, following Bikramjit, also held that you get it. All right, so these are the slight things that have slightly cushioned the impact of UAPA. But basically, that you will be denied bail as a rule and rot in jail till your trial starts or never starts is the most heinous form of preventive detention. And I wish the Supreme Court would once again look at UAPA and say that the statute is unconstitutional. Anyway, now I want to say a few words, because time is very short, on sedition. So sedition 124A, the old English law was, if you think against the Queen or against the King, or you say utter a few words against the King, you can be caught and put into the dungeon. No doubt about it. Heinous law. We took the same law from the British. The British had repealed the law. Countries across the world repealed the law, but India carries on. Because the Indian mindset at the top, and particularly today, is a very draconian mindset. Nothing to do with democracy. Our leaders of all political parties, take any political, nothing to do with democracy. Worse than the British. Can you imagine? We fought the British because they were draconian. And now they're chelas who come to power and, take powers, control state power, do things 100 times worse than the British. 100 times worse. Brutality, many, many, many times worse. Now, sedition, if you look at the section 124, it says you use words against the state which has the tendency to upset, disrupt, whatever. Use words. That's sedition. Now you would think Khalistan Zindabad. I suppose anyone listening to this talk, Khalistan Zindabad, asking for the breakup of the country. AZADI from India. I suppose all of you, not all of you, many of you listening to this lecture will say, oh my God, that's sedition. And it's been used for much, much lesser things. Like Kishore Chandra, the journalist from Manipur, who really detested his chief minister, and he told him one day in a public meeting, press conference, he told him, F-O. They caught him and put him in jail. 1 year. Renowned journalists for using an expletive against his chief minister, get into jail. Posters saying Inqilab Zindabad, go to jail. CAA and RC, go to jail. AZADI. And so in 1963, the Supreme Court in Kedar Singh's case said, this can't be the law. This is unconstitutional. This is a pre-constitution setup. So now with the constitution, we have to test it against the constitution. It's clearly unconstitutional. So what they did was they added a requirement. At first, you must use strong words of incitement, but not good enough. Unless you engage in an overt act. You must throw a bomb, you must fire a gun, you must gather a large number of people, throw grenades, so on. Then the words and the action constitute sedition. It's like waging war against the state. But if you're not engaging in any overt action, even fiery speech is all right. Even the most rough speech is all right. Unless hate speech. Hate speech is a separate component where you say things against the minority community and on the basis of religion. That's a separate category of crime. But otherwise, you can spew hatred against the government. Our constitution allows it. You can say, I hate this minister, I hate this prime minister, he's a useless fellow, and so on. And hate speech is perfectly purposeful. It rankles you, it annoys you, it irritates you, it sends your blood pressure up, it sends you into a fury, but it's constitutionally protected. And normally people in a democratic country are rugged people. They say, all right, he's just talking. He's not throwing any bombs or anything. And so there were two cases. I'll give you those two cases quickly. One is a case from Punjab where somebody said, Khalistan Zindabad, and said, my friends, we must get together. We must get arms. We must raise an army and have a particular part of India carved out as Khalistan. Went to the Supreme Court. And the Supreme Court judge asked, Mr. Prosecutor, I understand. He said this. But at the end of it all, what did he do? And the prosecutor said, Lordship, nothing really. Any violence? No, sir, no violence. So what are you doing arresting him? And they acquitted him. And the Kashmir case is also important, particularly in today's political environment. Azadi, and he said, look at the language. We must raise an army of people and arm ourselves and fight for independence from India. But he didn't do anything. And he was also acquitted. Therefore, the sum and substance of sedition law is that you must, absent violence, there can be no sedition. Now, you'll be very unhappy to know that there are thousands of people in jails, thousands of people in sedition. And reading the newspaper, every day you will see some, bully of a politician, some bully of a policeman, threatening you with sedition law for speaking out against government. Bad government. Generally in India today, rotten government. Corrupt, violent, immoral. You will find day in and day out cases. And do policemen care about, what the Supreme Court has said? Nobody cares. Few outstanding officers who, as the days pass, find it very difficult to continue in the police force. Poor fellows. They join to serve the nation. They join to bring law and order. They join to serve the poor in the police force. And they are now in a force which is the principal enemy of the people. Along with this, that, and the other, and so on, who are also principal enemies. The police force is also a body of significant organized crime. All kinds of guys organizing. Some new party comes to power, then they'll all organize and do things, break the law, and prosecute people who are against, let's say, a government or against a politician. And so, my dear friends, sedition law is being used again and again and again to keep thousands of people. Now, sedition law you can't prove, so you can't win your case. Because sedition law, when it comes to the court will say no violence. Where's the violence? Where's the injury? Where's the killing? So what you do in a sedition case, you do the case, do the charge sheet, arrest the person, and keep him in jail as long as possible. Slowly now the courts are realizing that we can't keep people on these stupid sedition charges for years and years. But in rural areas where people are caught for protesting and so on, who gets the lawyer? Who understands sedition law? And among the middle class people, everyone thinks these two examples that I gave you, Khalistan Zindabad and AZADI from India. In fact, I lost a case recently in the Delhi High Court, where the person said, Khalistan Zindabad. And I said, sir, here's the Supreme Court judgment. There's no violence. I lost it recently. So you can imagine what the situation in the country is. A terrible, terrible weapon of oppression. So it is detention. But it's detention without using that term. It is detention by saying sedition. It is detention by saying UAPA terrorism. But it's a tweaking of the system. It's a twisting of the system where bail will not be granted. And now, the end result is, you will hear it in the papers, that these acts such as terrorism acts and so on are ineffective laws. I'll finish now in about 5 minutes. I realize I've overstepped my boundary. These are ineffective laws because the conviction rate is 10% or 20%, I think less maybe. So these are ineffective laws, it should be repealed, not realizing that these laws are not meant to go through with the prosecution. They're not meant for that. They're not meant that the police will, really do an investigation, fingerprints, and all this sort of blood samples, telephone tapping, and put wonderful evidence before the court, and the court will convict. They're not interested. They're not interested in all the scientific evidence. They want you behind bars, and they don't want to take the effort to investigate. And very often, for the simple reason that really the person has committed no crime, but he's a thorn in the side of the government. So the real reason for the enactment and use of these laws, sedition laws and UAPA terrorism, there are genuine cases of terrorists, no doubt. And our police force, for whatever I've said about them, one thing you must say, that the police force, if they want to get a criminal, they will get that criminal. In that sense, they're a very sturdy and robust force. What leave alone, let aside the means that they use. But you can't pull the wool over the eyes of the Indian police. They're very, very competent in that sense. So it's not the intention, really, to try and gather evidence against the person who is not engaged in violence. So when after 5 years, let's say, of detention, you are released, and there are so many of these orders. And when you study these orders, not a shred of evidence, unable to prove beyond reasonable doubt, unable to show the court even a single. When you read the order, the judges are perplexed. Why did you keep this man in jail for 5 years? If in fact, as the order shows of the trial court, acquittal order shows, there was not a shred against him. Like Natasha's case, because nothing. I'm only reading your charge sheet. I'm not even listening to what the accused have to say. Your charge sheet cannot establish a single crime. Gogoi's case, same. I'm ignoring what the defense has to say. I'm looking at your document, and your document doesn't set up the crime. And so, my dear friends, I'm so happy to see Mr. Ribeiro and all my friends here today. And I said I must come when I saw their names on the whole thing. And I urge you all, young and old, even in the twilight of our lives, as we get older, we can become bolder. We might have been sort of wishy-washy in our youth, but we can be very sharp as time passes. And we have very little time left because tyranny, fascism, violence by the state is unbearable today. And I came only to say that we must stand up against this kind of oppression, no matter what the consequences are. Stand up and speak. Stand up and oppose. Stand up and fight back. Thank you very much. Thank you very much.
Thank you very much, sir, for your inspiring and insightful speech. Now, I would like to request the audience to put their questions in the chat box, or anybody who wishes to unmute and ask questions can raise their hands so they may be recognized accordingly. Anuj, you can go ahead.
Thank you, Tanay. Good evening, sir. Sir, my question is regarding the significance of right to legal counsel or lawyer in preventive detention laws, and what is the rationale behind the nations and states or the government denying the right in certain circumstances. I went through Article 22, Clause 3, Subclause B, which strips the right of legal counsels from the persons arrested under preventive detention laws. So does this question and your insights would be really valuable for the same, sir.
Well, like everything else in India, everything is great on paper, but everything is pretty bad when it comes to actual reality. Take, for example, and the state boards and the central board and NALSA and so on. And I suppose it's better than nothing at all. But when you look at legal aid being provided in India to the poor, it is in a miserable state of affairs. Nobody will say it. Nobody wants to say it. No judge wants to acknowledge it. So what do? Take, for example, the Delhi riots. People rioted. There were two persons very prominent from the party in power at the center, and a minister of state, no less, who said, Desh ke gadaro ko de goli maro salo. Right? So many people got injured, so many people died, so much property got destroyed. Who gave the victims legal aid? Nobody. Take all the lynching cases in the country. Somebody ate meat, he was lynched. Take all the rioting cases. Who gave them legal aid? Nobody. Take all the communal attacks in this country. Nobody gave them legal aid. So legal aid to the government means, and to the statutory boards and so on, means that when it comes to court, when the case comes to court, then the judge will feel sad that the poor person doesn't have a lawyer, I'll give you a lawyer. Face saving, I call it. But there are massive areas, tribals. Can you imagine? An environmental organization went to the court and said evict tribals, and an order is made for the eviction of 1 million tribals. Who gave them legal aid? Who gives the tribals legal aid? Who gives the Dalits legal aid? Who gives the working class legal aid? The millions of workers, migrant workers walking across the country, who gives them legal aid? Face saving. Beautiful table on a Saturday, white cloth, flowers. Everybody will stand and read out prepared speeches. That's your legal aid. So it's a right, you're right. It is a right. But like everything in India, it doesn't exist on paper. It doesn't exist in reality. It exists on paper.
Thank you, sir. So we have one more question in the chat box. The question goes as follows. Even in cases of no violence, at the end of the day, what about inciting people to undertake something which is against the integrity of the nation?
A simple answer, and backed up by a number of judgments. You say something foolish. I gave you two lovely examples. Palestine. We must raise an army. AZADI. Again, we must raise an army. You're inciting people, correct? But if your incitement has No effect at all. Supreme Court says this is a trivial thing. Person spoke, said something, and the judgments are you can say something harsh against the government, ruffle the feathers. It is better to let a few noxious branches grow. Noxious branches. A person may say it's noxious what he's saying. How can he speak of breaking up India? How can he speak of taking a part away? It's noxious, it's obnoxious. Correct. It is better to let a few noxious branches grow than to stifle free speech. Said something of no effect, leave it. India has broad shoulders. India is a powerful country. We don't get, our police force is not supposed to get involved with every, person who says things. No. Takes to violence, you stop him.
Yes, sir. So I believe that were the questions. Thank you very much for joining us today. It was great having you today, sir.
Thank you all. Thank you.
Now moving towards our next panelist for today, Shri VP Raja sir. Honorable sir, before you express your views and opinions on this subject of the preventive detention laws, I would just like to give a brief preface to the audience with regards to these preventive detention laws in the pre-independence era. We are aware that these preventive detention laws were not a creation of the post-independent India. Certain events and happenings in the history of our country provide testimony to the existence of these laws, of the laws belonging to the kind of these preventive detention laws during the British rule and even during the rule of kings in the ancient Indian history. For example, the passing and implementation of the Rowlatt's Act 1919 by the Imperial Legislative Council. Hence, with regards to this, I would like to request you to enlighten us on the basic principles of thoughts and morals which lead to the formulation of such legislations.
Thank you, Tanay. Yes, it is true that preventive detention has had a long history, but since one has to start somewhere, in a certain sense, if we talk of Western dominance, if you have to put a date, I will say starts with the arrival of Vasco da Gama in the Cochin port, 1498. That was the period where certain European powers, because they had become adventurous, were seafaring, they were discovering new lands. Many perished, as all of you are aware. Even America was discovered and became a colony of Britain. Then doing a fast forward, we have the East India Company becoming the de facto ruler of India with a kind of a soft remote control from Britain. So even if you go through the laws during the period when the East India Company was de facto in control of a part of India called British India, and in the princely states, the princes and the nawabs had agreed to the superior power of the British, and they had just kept some watch on what is happening there. So that is the period of the East India Company. And then after the first, we call it the First War of Independence, 1857. The British call it the Sepoy Mutiny. History is always written depending on who writes the book and who wins. So from 1857 onwards, Britain takes a more direct control. And then the acts passed after that period. In fact, starting right from 1858 onwards, the British Parliament takes control of India. And some changes, things happened in various fields, both on the way to administer the so-called sovereign functions of the state. That is criminal justice system and land administration also followed different patterns. The Bengal presidency had a system called the Zamindari system, while in what is now Maharashtra, the Bombay presidency had a completely different system called the Rayatwari system. Various laws came, as Tanay mentioned, one of the most ferocious in terms of preventive detention. By the way, before preventive detention, you must also realize that there was this First World War, 1914 to 1918, and India was helped as a British colony in the World War. I think we sent more than 1 million soldiers, that is from India. So during the wartime periods, both during the First World War and the Second World War, there were special laws called the Defense of India Act and the Defense of India Rules. But after the First World War got over, it's interesting to know the Britain at that time faced maximum resistance from what is now Punjab, that area. That is a separate history. The separate history is about 10 years prior to that, a lot of Punjabis tried to go by sea in a kind of an old ship to Canada, and they hoped that they will get admission there. They were all turned back. Nobody was admitted, only on the ground of race. So that was the kind of, so these people who had traveled by sea for many of them for 6 months, 7 months, were not admitted in Canada, came back. So to understand society, one has to live back those years by reading history of that period. So with all this, there was a British judge called Rowlett, and he drafted an act so that the state wants a lot of control. When things go wrong, you want more control. That happens again and again. So that's how this Rowlett Act of 1919 passed early 1919. It was called the Black Law because it was very, very repressive. It was in effect a preventive detention law. If you suspected anybody that who is likely to work against the interests of British India, you can just detain him. As simple as that. But this was resisted, and Mahatma Gandhi's major satyagraha, because he had returned from South Africa, he had not become as prominent at that time, but one of his first major satyagrahas was against the Rowlett Act. Then actually two people called Kichlu and Satyapal were arrested in early April under the Rowlett Act, which is a Preventive Detention Act, which increased tempers. People wanted to kind of, prohibitory orders had been issued, and people congregated. It also coincided with Baisakhi, and that is the background to what happened in Jallianwala Bagh. Of course, today there is another controversy on Jallianwala Bagh being made a tourist center, but I won't go into this. But the 1919 Jallianwala Bagh, Gandhi himself was coming to that place, but he was arrested before he entered. So that was the kind of preventive detention laws that existed. Now again, fast forward, 1935, we have the Government of India Act. And we must remember that even after the formation of the Constituent Assembly, historically, we were always making incremental changes. That is, the entire concept was change with continuity. And now, when the Constituent Assembly was there, India becomes independent, 1947. What is the position at that time? The partition violence commences once the decision was announced, starting a couple of months before 15th August 1947. Then immediately after independence, our first Home Minister, Sardar Patel, was working for the unification of states. And as you know, 3 states were holding back. One was the Nizam of Hyderabad, second was Junagadh, and third was the state of Jammu and Kashmir. Now, when you read through the history of that period, even a person like Mahatma Gandhi was not very much in favor of use of force. But Gandhi got assassinated. Thereafter, force was used to add the Nizam state of Hyderabad into India. That is, there was a big movement there called the Razakars movement. So if you see what was happening in society, Sardar Patel himself felt that there is need for preventive detention. So, and we had more or less this so-called the 7th schedule to the Indian Constitution we have. It goes back to the Government of India Act 1935. That is why if you open the 7th schedule to the Constitution, you will find preventive detention as entry number 9 in the Union list, that is list 1 of the 7th schedule. And you will also find in list 3, the concurrent list, entry number 3 as preventive detention. Which means today the situation is both the state governments and the union parliament and the state legislatures have power to make preventive detention laws. And as the Honorable Principal of the Government Law College in our opening remarks mentioned, there have been various preventive detention law. The first one was piloted by Sardar Patel in the year 1915. And well, looking back, that also was, well, depending on your ideological position, misused. That's what led to the A.K. Gopalan case. Because at that time also, you know, the left or the communists, the CPMs, were kind of politically speaking untouchables. Anyhow, the principal has already given you that. So when we talk of preventive detention laws, there are a large number of preventive detention laws. To name a few, you have the National Security Act 1980. You have the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. You have the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. You have the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. You have the so-called KOFPOSA. And Maharashtra has its own other preventive detention laws. So actually, a number of preventive detention laws are in the statute books even today. Some got repealed, some have not been repealed, some got substituted. That's one point to know. Now, before we go into that, the normal law of the land also provides for preventive detention. Our good old Criminal Procedure Code. The Criminal Procedure Code 1898 provides for preventive detention. It went through major changes in 1973, and what we now follow is the CRPC of 1973, which basically separated the preventive powers and the whatever is to happen for preventing crime and whatever is to happen after crime. But if you read section 151 of CRPC, it provides for preventive detention. Please remember, CRPC, the legislative strength comes from entries 2 and 3 of the concurrent list. That is, the preventive detention strength comes from entry 3 of the concurrent list. CRPC itself is entry 2 of list 3 of the 7th schedule to the Constitution. Because it is in the concurrent list, it is possible for states to have local amendments. And Maharashtra has a local amendment. In very simple terms, the local amendment provides that in Maharashtra, if a police officer or even a constable uses with a view to, under suspicion that somebody is about to commit an offense, he can arrest him. He has to produce him before a magistrate within 24 hours. But he can tell, the police officer can tell the magistrate that these are the things he suspects that the person is planning, and the magistrate is authorized to extend the detention up to 15 days at a time, and totally it can be extended up to 30 days. The reason I'm mentioning this is the normal law of the land. Under the normal law of the land, you can use section 151 of the CRPC and keep a person behind at least for 15 days or 30 days. I must now confess that while working as a district magistrate, I have used this provision. I will tell you that to explain what it will also bring out that what this. I was collector and district magistrate at Satara. Around that time, an organization had sprung up a few years before that, or a number of years before that, in Sangli. The name of the organization was Hindu Ekata Andolan. The reason that organization came up was there was an excellent, that college still exists, an excellent, outstanding medical college at Sangli, the Sangli Medical College, which has a good reputation today also. And a lot of people from the Middle East, Arabs, used to come to Sangli for treatment. They will be in the hospital for 1 month, 2 months, etc. And not everybody, but a certain kind of racket also commenced, where these very rich Arabs used to marry girls in that area, Sangli, Satara, that area, and then take them back to the Middle East. But after taking them back to the Middle East, they will literally be used as domestic servants or, basically as a slave. So I won't say that this was not happening at all. It was happening. Not that everybody was doing it. But to fight this, an organization came up called the Hindu Ekata Andolan. Headquarters Sangli, but they had branches in Satara, Karad, etc. On one day, late in the evening, at about 7 or 7:30, I got a message from the so-called home inspector, the police control room, that crowds are collecting in a main intersection at Satara, and it can lead to communal tension. So obviously the police moved in, a lot of people were picked up. And then it started with a rumor that a Hindu girl was being carried in an auto rickshaw. That is, the driver of that auto rickshaw was a Muslim person. And that auto rickshaw was going up the Khas hill. Khas is a little, you can call it a minor hill station in Satara. And that had been seen by a number of people, and a rumor spread that something illegitimate and illicit is happening. And that spread of the rumor led to people collecting. And this rumor spread like wildfire. It went to Karad, in Sangli, because those days there was no internet, but through normal telephone messaging also, it goes. And then we had, for the next 4 or 5 days, 1 or 2 incidents every day of some looting, some auto rickshaw being kind of set on fire, these kinds of arson, not very major, but every day one or two such incidents. And it started happening in Karad also. Karad started blowing up much more than Satara. Now the problem was Vijay Dashmi, that is Dashera, was coming very soon. And in that particular year, Dashera and Eid were coming on the same day. Most of the people involved in this scoot and hit kind of violence were students perhaps of the age who are attending this webinar today. Students in the age group of, let us say, 16 to 23, that kind of a thing. So myself and the Superintendent of Police, we decided to pick up a number of students using 151 CRPC. Most of them in Karad. Obviously, in a peaceful fashion. But the moment you pick up students, I was also camping in Karad. The SP was also camping in Karad. Parents started ringing us up. Why? What? Obviously, parents get very concerned. Anyway, we had to say that we'll treat them well, no problem, etc. And we had to produce these students before the judicial magistrate within 24 hours. Then when we made inquiries, we found that the judicial magistrate first class was living as a tenant in the house belonging to the chairman of the Hindu Ekata Andolan. Now you have a little, you have a doubt by what is, you don't know what is happening, but these are very strange. But a doubt comes, will the judicial magistrate be able to function without fear of favor? So on that occasion, I actually...
Sir, you are gone on mute.
When did I get unmuted? Muted?
Just few seconds ago. Just
Okay.
a few seconds.
So I talked to the district judge on telephone, drove to Satara, and the district judge very kindly, this is all oral, permitted me kindly bring them and place them before the judicial magistrate first class Satara instead of Karad. And we explained the position very frankly, saying it is to prevent law and order, because Eid and Dashera are coming on the same day, and we don't want this to explode. And we were granted 15 days, further extension of detention. But we were quite kind in the sense when parents started approaching us, we said that if you take your boy or girl, mostly boys, you take them away from the district. You take them to your relative's house in Nasik or out of this district, and don't bring them back till the Dashera function is over. We are prepared to release them. So some of the parents took away the children, but this was the condition that you can't bring them into the district till the Dashera and the Eid events are over. The reason I gave this example is if you go through each of the preventive detention laws, they have some, I right now didn't talk about preventive detention, I talked about the normal law, 151 CRPC with the Maharashtra local amendment available within Maharashtra, where in effect, you can keep a person about to commit an offense, where you suspect a person is about to commit an offense, totally up to 30 days. Of course, after going to the magistrate. Now, the various preventive detention laws which came in India, the latest being mentions were, by the way, POTA and sedition laws are strictly speaking not preventive detention laws, but what is happening is they are all being used as a proxy for preventive detention. That is what is happening. Actually, Article 22 of the Constitution, that protection is not available in UAPA, and sedition is part of the Indian Penal Code. It is the normal criminal law of the land. But these acts which were mentioned is true, is all being used as a proxy for preventive detention. And as Advocate Colin Gonsalves very rightly pointed out, particularly after the so-called Vatali judgment given, I think, by Justice Kanvilkar of the Supreme Court, it has become very bad, which means you have to read section 43D5 of the UAPA and the default or statutory bail provisions of the CRPC together to understand how the entire thing is getting abused and misused. So I will say, and similarly, if you go through, of course, sedition, right now the Supreme Court has at least stated that they are prepared to look into it. So hopefully it will come up. And let's hope, like some of the great judgments that came a few years ago, decriminalizing homosexuality, ruling that privacy is a right to privacy is a fundamental right. I'm still hoping that a day will come very soon, perhaps in the next few years, when sedition may go out, will be found to be unconstitutional. That is 124A of the IPC. But when it comes to UAPA, I'm afraid if you go through the statement of objects and reasons for UAPA, for that one must understand the history of what has been happening with terrorism. In fact, if you read through the statement of objects and reasons, even if you go through the preamble of the UAPA, a lot of it has to do with Security Council resolutions and the fact that we are part of the United Nations. It is part of what can be called as an international effort to curb terrorism. That is because, thanks to the global village, thanks to money, the linkage of how terrorists gets funding, all these are interconnected. So the Security Council has discussed and passed a number of resolutions in this matter. And under the Security Council resolutions, it is necessary to name organizations. Because if you name organizations as per that Security Council resolutions, then you can, you can name it. That's why the amendment of 2019 for also including individuals, in a sense, was included so that you can name, let's say, Dawood Ibrahim as a terrorist. Then it has implications because the United Nations can issue sanctions. Again, and on some organizations, such work has been done. So the aim and objective, of course, can be debated. But what cannot be debated is there is large-scale abuse of these provisions. That is, these provisions are being both sedition under 124A and UAPA are all being abused. And this abuse means it is being used on people on whom none of these charges, as very correctly pointed out by Colin Gonsalves, where if you go by the evidence which is admissible under the Evidence Act, most of this will not charge. Why go this far? We didn't use, we had this, the present government came to power after talking a lot about corruption by the previous government. So you have these various scams. I won't deny that the scams have not taken place. But the beautiful thing is, one of the big scams was the 2G scam, where the Comptroller and Auditor General said that we have incurred perhaps a notional loss of this much, without understanding that the cabinet obviously is not working to make money. It is what is, if the 2G spectrum had been auctioned instead of being given out on a revenue sharing model, the amount of internet penetration that has taken place in India would never have happened. But that's a different story. But in the court, the case against Mr. Raja, who was the telecom minister at that time, could not be established because the entire huge amount of documents produced were all newspaper cuttings, etc. Most of which will not fall under what is admissible as evidence. What is the fact in issue? What are the facts relevant to the fact in issue? And that is listed in the Evidence Act. So that case was thrown out. So I completely agree with Advocate Colin Gonsalves that the quality of investigation being done by the police is, what word do I use? Laughable. But that is happening because of the civil services listening to political executives' oral commands rather than going by the law. And this problem certainly has worsened over the years. Nothing to do with the last 7 years. It has been happening over the last 30 years. Things were better. I remember, I think I was together with M.N. Singh. I was a sub-divisional magistrate when Mr. M.N. Singh was the senior superintendent of police in Aurangabad. That was the time when I think emergency was on. And I remember a case where somebody had been arrested. The powers were with the district magistrate. Arrest had been carried out, and you have to go with all the papers to an advisory committee. MISA had that safeguard of Article 22 of the Constitution. And I remember one case in my jurisdiction where the advisory board set aside our order only on the ground that the order is in Marathi with an English translation, or perhaps in English with a Marathi translation, while the person knows only Urdu. Of course, everything had been explained to him in Hindustani, but the court did not accept it, saying that this order is defective because the grounds of his preventive detention under MISA has not been given to him in Urdu. So, which also means that the advisory board around those periods of 1975, 76, etc., was working reasonably well. They were going by the letter of the law. So, seen from that angle, things have certainly decayed. Now, this decay is my personal view, is because of, our so-called political leadership and also the civil service leadership. Both are to blame because this can happen only with collaboration between the concerned officers in charge at a certain place at a certain time and the minister. It can't be done without collaboration. There is a decay, which is worrying. I like to mention one thing. I was a student at Columbia around 1969, 68, 69, 70, that time. At that time, in the Western countries, all universities there were protests going on. The main anger was the Vietnam War. That is, there was a lot of anger against Western involvement in the Vietnam War, the US involvement. They used napalm bombs to kind of literally put hectares and hectares of land using napalm bombs under fire, and the students were protesting. Now, these student protests was not merely in American universities, it spread to European universities, including in Paris. So when the universities in Paris started literally, a lot of protests, the cabinet of France at that time, and the protests increased when one of the well-known academics at that time, whom the students liked a lot, this philosopher called Jean-Paul Sartre, he kind of supported the student movement. And amongst the political parties, the communist parties, the leftist parties were supporting the movement. And Jean-Paul Sartre was not a Marxist. He, as you know, is an existentialist, but not a Marxist. But when the press asked him, why are you supporting? He said the students' agitation is right. And now the left parties are supporting the student agitation. I am supporting whatever I feel is right. And that increased the pace of the student agitation. Jean-Paul Sartre's involvement in this agitation amplified the agitation. So the French government in the cabinet meeting unanimously decided that we have to now preventively detain this philosopher Jean-Paul Sartre. I don't know the French law, either because of the French law or because he was a very, very prominent person. The cabinet went with the proposal to President de Gaulle, who was the president of France at that time. President de Gaulle heard the entire proposal, all the arguments, very patiently. And his reply was a single sentence. You can't arrest Voltaire. Who am I? I may be the president. But who am I, or who are any of us when you think of Jean-Paul Sartre? He is today's Voltaire of France. So the president did not permit the arrest of Jean-Paul Sartre. Now you compare this with the people being incarcerated in the Bhima Koregaon case. Many of them, I'll agree with Colin Gonsalves, are like the Jean-Paul Sartre, are the great intellectuals of India, whom we ought to salute. We may agree with the views, we may not agree with the views. That's a different point. But I'm reminded of this statement of Jean-Paul Sartre, and you can do a Google search on this and get the full information. What this brings out is, if you have leadership who are statesmen, I read an article recently where, in that article it is mentioned, had Atal Bihari Vajpayee been the Prime Minister, he would have dismissed his minister who used inappropriate, that's a small word, language, but that has already been mentioned by Advocate Colin Gonsalves just before the Delhi riots. He would have been dismissed the next day. So it all depends on leadership. These laws per se can be debated, whether we should have, not have. It is to do with this very plural nature of the society, and the fact that there are always fringe elements, and the fact that terrorism has become international in scope with connections to drug funding. So you can't solve it as a local issue. So I am kind of, the jury is still out whether you can manage a country with only 151 CRPC without all these extraordinary laws. But that's debatable. But even if they are there is absolutely no justification for its abuse. And the final answer to this is, we have to clean up our election system. I mentioned in another occasion, only today morning, that if you go through the figures published by the Association of Democratic Reforms, based on information compiled by the Election Commission of India, in the 2014 parliamentary elections, the total money spent by all political parties was 25,000 crores. While the total money spent by all political parties in the 2019 parliamentary election is 60,000 crores. So money power playing a bigger and bigger role, where the electoral system, the constitution, everything is gamed by inappropriate people coming to power. That's a matter of concern. The second matter of concern is criminalization of politics. I worked in the Ministry of Defense. My own boss, Mr. N.N. Bora, who later became Home Secretary, did a report on that long time ago. That would have been I think I was in defense 1996 or 7 or something like that, almost more than 25 years ago. But in spite of that report, criminalization in politics have increased. As per the figures released by the Association of Democratic Reforms, 44% of our honorable members of parliament have criminal charges, if it gets established, will lead to at least 2 years and more of rigorous imprisonment. Of course, it has not been, they're all pending in courts. So I think cleaning up our political system, both in terms of the impact of money power and the impact of criminal power, that is the muscle power, that is the answer to this. The abuse is taking place because very powerful laws, which as per the statement of objects and reasons in the preamble, have good noble purposes to achieve, are being used by petty small minds. I think I will end what I wanted to say. Thank you.
Yes, sir. I thank you very much for that insightful address indeed. And we were actually expecting a true anecdote from your side, any personal experience from your side with regards to this case. So thank you very much again for sharing with us that personal experience. And considering the time now, we are going to have a question and answer session later. So I may request everybody to hold on with their questions, and we can have the question and answer session even later. Now moving towards our next panelist for today, Shri M.N. Singh. Respected sir, to detain someone in order to prevent the committing of a crime can always seem to be a good provision available at hand. And the exercise of this provision by the police in the dire times of need can always be justified as an act for the greater good of the masses. But we have seen certain cases where the citizens have questioned the motive of the detention to be different than from the prevention of a crime. Hence, sir, on the lines of this, I would like to ask you that what is the utility of the preventive detention laws in the contemporary period in a democracy like India? And does it really help to strike the balance between various coexisting and competing rights of the citizens? Or does it really help to preserve the morals and values of humanity while maintaining the state of law and order at the same time? No, sir, actually, we cannot hear you.
Hello.
Yes,
Can
sir.
you
You are audible now.
can you hear me? Hello. Can you hear me?
Yes, sir, we can hear you, but there is a
Hello?
slight echo at your end.
Is it okay now?
Yes, sir, you are audible.
Hello.
Yes, sir, you are audible.
Hello.
Yes, sir.
Yeah, problem. Yeah. Can you hear me?
Yes, sir, yeah.
Hello. You can hear me?
Yes, sir, we can hear you, yeah.
All right. Okay. Now there is very little time left. So instead of saying anything, I would only respond to the presentations made by the earlier two panelists. Before I do that, I want to thank Mr. Ribeiro for asking me to join this discussion. Mr. Ribeiro was my police commissioner when I was his deputy commissioner way back in the early 80s. And as Raja said, Raja and I worked together in Aurangabad district sometime in the mid 70s. So I have very cherished memories of those days. Now, you see, when I was listening to Colvin Gonzalez, I was a little confused because he talked a lot about cases made out by the police, like prosecution cases and police filing up false cases and all that. And he cited examples of sedition law and all that kind of it. That the topic of debate was detention law before independence and detention law after independence. So, which Raja later on elaborated upon, and he gave a good detail of all those preventive laws and the background and all that kind of a thing. So that part has been covered now, but I would like to respond to what Advocate Colvin Gonzalez said. He has a lot of complaints about this thing, about the false cases being hoisted upon people and bad investigation by police and things like that. Let me briefly say something about the state of our criminal justice system in the country. I would like to remind Advocate Colvin Gonzalez and others that way back in 2009, the then Prime Minister of India, Dr. Manmohan Singh, said in the Parliament that India had the largest backlog of cases in the world, with 30 million cases pending in various courts. And of this, 4 million were pending in the high courts. 65,000 cases were pending in the Supreme Court, and the rest in the district courts. This figure does not include the cases pending in various tribunals. So this is the state of affairs of our judicial system. Then in 2009, the then Chief Justice of Delhi High Court, he publicly said that it would take 466 years to clear its backlog. There were 600 cases which were more than 20 years old. Now, this is the state of affairs of our judiciary. And add to this delay, the High Court, the high cost of litigation has made the judicial system prohibitive for the common man. As a result, India's legal system has increasingly become the preserve of the country's wealthy and well-connected people. Now, this is the state of affairs of our judiciary. And now let me also say a very recent example of an advocate having been arrested by CBI. There is a very high-profile case going on these days. The Enforcement Directorate and CBI are investigating our ex-Home Minister, Mr. Anil Deshmukh. In that case, his own advocate has also been arrested because he bribed the police officer of the CBI at a lower level, and he tried to get a false document prepared, which is cited in the court. Now, this is the state of affairs of our criminal justice system. It is such a sorry state of affairs. I have absolutely no hesitation in saying that our criminal justice system in the country has collapsed. Whatever the courts may say, Advocate Gonsalves cited so many examples of the courts chiding the police officers and rebuking them. That's a very one-sided proceeding going on in the court. The courts may say anything, but the police officer there has no right to say anything and rebut it. So that is, unless, first of all, I want to say that correct the criminal justice system, improve the laws, and avoid and prevent the delays if you want to improve really the justice delivery system. Because dispensing justice among the most basic services of the state and is expected to render it to the citizens. Now, the facts given above make it abundantly clear that the Indian state has failed miserably in discharging this duty. Now, this is the comment, that it is one of the primary duties of the government, of the state, to dispense justice to the people. And if the government fails in this, I think it's a very miserable failure. And what is happening today is a result of this failure of the criminal justice system. Now, Advocate Gonsalves cited many cases of wrong cases being watched. He cited the example of sedition. Let me tell you, and also UAPA. Let me tell you, first of all, Mr. Gonsalves was totally wrong. UAPA is not a detention law, nor is Section 124A, that is sedition, requires any violence. If you read the basic sections of basic reading of Section 124 of the Indian Penal Code, which is about the sedition, it says whoever by words either signs, brings or attempts to excite, disaffect, commits an offense of sedition. There is no mention anywhere about violence in this. This is, I think, the very basic law. I'm sorry that Advocate Gonsalves did not know even this basic fact. Now, similarly, TADA Act or POTA Act or UAPA Act is not a detention law. Our topic of today's discussion is detention. Now, if there is a misuse of law, yes, of course, that's a problem. Now, let us address that problem. But let me tell you that the world over, including all the major democracies in the world, have enacted anti-terror laws and detention laws. Because the world at large has realized that the terrorism has become a global phenomenon and is a big threat to the peace and security of the world at large. And therefore, as Raja said, that the United Nations itself, in many of his resolutions passed before the United Nations General Assembly, as well as the United Nations Security Council, has advised all the states to enact appropriate anti-terror laws to check terrorism, to check funding of terrorism, and to check travel of terrorists. And United States of America, after 9/11, enacted a law called Patriot Act, which even entitles it to check people entering United States of America and deporting them and not allowing them to enter. Now, you can say that this is a very harsh law, but the thing is, if you don't law, don't have weapons, then unless there is a violence, why do you arrest? People are saying Azadi, Azadi, and let us gather together, let us raise an army, as Advocate Gonsalves said. But what is, unless there is a violence, why? I mean, it's a very strange logic. I'm not in agreement with him. Unless there is a violence, people can go on saying whatever they want to say. People can go on to the extent of even saying that you collect weapon, and let's fight for our Azadi. What does it mean? Where is the need to collect people and to collect weapons? I mean, if we are going not to take preventive measures at that stage, then probably it will be too late to act, and nothing will then in that case. Now, as Raja said that there is enough provision in the ordinary law, like the criminal procedure, where you can arrest people as a preventive step. Yes, there are. Also, let me also tell you that many people are making mistakes. What is the arrest in the crime and the difference between arrest in crime and detention? Now, detention law is actually a preventive law. And the definition of detention is the object of the preventive detention is not to punish anybody, but to intercept, to prevent the detainee from doing something which is prejudicial to the state. And the satisfaction of the detaining authority is only a subjective satisfaction. Now, from the time we became an independent nation in 1947, soon after independence, when the Constituent Assembly was set up and the Constitution was drafted, there has been debate in the Constituent Assembly about introduction of these provisions in the Constitution itself. Mr. Raja cited those examples of list 1, concurrent list, and the central list, and he has quoted all those provisions in the Constitution. So there are provisions adopted immediately after the independence. The Defense Act of India was enacted way back in 1950. Soon after only 1 month after the Constitution was adopted, in 26 January 1950, our Constitution was adopted, and in February, that Defense of India Act was enacted. And while the act was when the bill was being introduced in the parliament, Sardar Patel said, I had sleepless nights while thinking of introducing this bill, but I have to introduce this because the situation in the country is such that we need a preventive detention law. And the situation was the partition violence in 1947, Pakistan's attack in Kashmir, then the reluctant royalties like Hyderabad, when there were Razakar movements and all that. All those kinds of situations were taken into consideration, and it was decided to enact preventive law. Today, that was the stage when most democracies did not have anti-terror laws or detention laws. But today, there is no country in the world which does not have a detention law, including the United Kingdom, United States of America, France, and so many other countries in the Western world, because they are all facing the problem of terrorism. And therefore, I think it will be very wishful to think that we control them by using about all the legal provisions, and I agree with him totally. Now, preventive detention, let us take it. That preventive detention law is a necessary evil. I do not call it as something which is normal. It is a necessary evil, but a necessary evil that cannot be avoided. Now, here, the principle of preventive detention has been permanently embedded in our Indian legal system because it is there everywhere. Now, most of the states are having also detention laws. Maharashtra has the MPDA Act, which with the problems of gangsters and slumlords. And recently in 2016, there was an amendment which it made even sand mafia is also included in that. The piracy things is also included into that. So you see, we are a very serious that a misuse of law has to be checked, and how to check it is all in the hands of the authorities. Now, remember, there's a lot of provisions available in the Constitution and the person who is detained. There are various sections have been articles of the Constitution have been quoted that the detainee has to be given informed about the grounds of detention within a certain number of days. Then the state has to confirm it. Then the matter has to go to the advisory board, which is headed by the judges of the High Court, some serving and some retired, and it has to be confirmed. Plus, thereafter, he has the right to move the court. There is a judicial intervention also. So he has all the facilities to do that. Whether he is able to avail of all these facilities or not, it is besides the point. But terrorism is a problem, or organized crime is a problem, which cannot be handled by the ordinary means of the ordinary law, because as I said, our criminal justice system is just not functioning. It is only once in a while it wakes up to make certain very strident comments about the police investigation. Although I know there are lots of problems in the police, but then unless the criminal justice system is reformed, let me tell you, I was investigating the 1993 serial bomb blast case. There were 600 interlocutory petitions. At every stage, the defense lawyers, and there were 30 defense lawyers appearing on behalf of the accused. And every stage, they would move a petition and try to stall the proceedings. It took 14 years to give a judgment in the 1993 blast case. Imagine. Now, if you have such laws which are so dilatory, which takes so much time to decide the cases and punish the culprits, how can you really deter these people, those who are criminally oriented? And therefore, that is why today the situation is such that all countries have adopted anti-terror laws under the advice of the United Nations General Assembly and Security Council. It is something which you just can't avoid, and that is why I said that the principle of preventive detention has been permanently embedded into the Indian legal system, and it is going to stay. The question is how to prevent its misuse. I can tell you that when I was superintendent of police at Aurangabad, when Raja was assistant collector, myself and the district collector at that time was Mr. B.N. Bhagwat. We had decided that every case of detention, the names used to come from the center, from Bombay. A list used to come that these people should be detained. And I had issued the instructions that all those people who are picked up should be produced before me. And if I am satisfied that they are fit to be detained, then only they will be detained. And the district magistrate of the time, he agreed with me, and we had absolutely no problem. Lots of people whose names came in the list from the government of Maharashtra, we did not detain. And we told the government that we don't think that this fellow needs to be detained because either he's so old or so inactive and it serves no purpose. So it is up to the authorities who have the power to detain, and it is by the responsive government to understand. I had no problem with the government. Only once Mr. Chief Minister asked me, you have been sending some lists and you are not detaining. And I told him, sir, we are examining all the lists very carefully, and where there is a need to detain, we detain. Where we feel there is no need to detain, it doesn't serve any purpose, we are not detaining. He kept quiet, he didn't say anything. There was absolutely no problem. The officers who have the power to detain, they must stand up and they must take a stand. I also remember when I was deputed for a serious law and order crisis, and I decided to pick up a few people. The Home Secretary of the time phoned me and he said, why are you detaining these people? And I said, sir, it's very necessary to detain. These are the people who are creating problems. He said, cannot that be done without detaining? I said, no, in my judgment, it is very necessary to detain. He kept quiet and I detained them. Similarly, there was one politician who was a member of assembly. He was an MLA. And I ordered the Commissioner of Police of Aurangabad to detain him, to arrest him, kept him under preventive arrest. And when the matter went to the Chief Minister phoned me. Mr. Sharad Pawar was the Chief Minister, and he said, I had issued instructions not to arrest him. I said, yes, sir, I was told about it, about your instructions, but in my opinion, in my judgment, he needs to be arrested. Otherwise, he is the biggest threat to the law and order. In my judgment, you must. Chief Minister accepted my judgment and he kept quiet. So there is a need to prevent these misuse of the powers. I know that there are lots of examples. I don't agree about the comments about the sedition law. If the Supreme Court wants that the sedition law should go, well, I'm too small a person to say anything. But I think it is very easy to demolish the building, but it is very difficult to construct a building. Let us not forget that. If we demolish the edifice of the justice system, well, there will be chaos all around. And I would therefore feel that we have to tread very carefully, very, very carefully. There have been cases where there have been serious misuse of this problem. I know that in some cases, in some state, it's about 78% of the detentions were set aside by the High Court because they were either detained for their participation in anti-CAA agitation or for cow slaughter, the violation of cow slaughter laws. These are the things which sometimes I tell you, it is not the fault of the officers, it is the fault of the government that be. And that is something I do not want to go into a political debate because I understand some of you are students and it is basically important for you. It's a learning process. So let me end up by saying, as far as the anti-terror laws are concerned, anti-terror laws have come to stay, not only in India, but all over the world. And anti-terror laws is as a result of a certain deliberations in the United Nations, both in the General Assembly and the Security Council. The advice is there for all the states to adopt anti-terror laws, and they have adopted because it has become a global problem. Let me tell you also that 9/11, when the World Trade Center in New York was attacked, and America decided to attack Afghanistan and go after those people. Now, that is the time when, in my opinion, that was the beginning of the Third World War, which is not a declared world war, because along with the United States of America, the NATO was involved in that. Western countries were involved in that. So many countries joined hands with America to fight this menace of terrorism. It is an undeclared terror, World War III, World War number 3. It may sound very bombastic and fantastic for me to say this, but it is nothing like that, because the entire world is affected by this menace of terrorism, and the world has to stand together to fight this menace of terrorism. Otherwise, we are in for a serious trouble. And to have these anti-terror laws is very important. There is no alternative, because the normal law and the normal judicial system has failed to check even the ordinary law, what to talk of, and you can see this everywhere. Then where there is a rape and murder of a girl, there is a hue and cry, including in the parliament, when the members of parliament have demanded that castrate the fellow and hang him, and we go for special courts and all these things. It only shows that the normal judicial system has not been successful in delivering the justice and in being a deterrent, and therefore that is why we are having this detention laws. And detention laws are there all over in all the states also. Therefore, I think to even think of do away with all these things is I do not agree with this proposition at all. These laws are, but I agree that there is a need to check the misuse of the law. How to check the misuse of the law is something which for the government to decide, and for the authorities to stand up before the might of the political bosses, because the politicians, I think that people are very ordinary. Like somebody, it was said that somebody said "Goli maro salon ko." I think that was a very childish kind of a thing, and he should have been definitely punished for that indiscretion. But well, I don't know the political compulsions, but whatever it is, it has become certainly a big embarrassment for the government. And I think such things should be avoided. There are people in responsible positions. Who is going to tell them you behave properly? They are the ones who are supposed to tell the rest of the country and the world to behave properly. If they do like this, I think this is a very, very sad state of affairs. And with these few words, I think I would have liked to say a lot more, but there was not much time left for me, because I would have certainly liked to say how the Rowlatt Act came and how our anti-terror laws have developed from stage to stage. I will just take a few minutes again to say, 1950, we enacted the Defense of India Act, which was enacted only for 1 year, but it was allowed to continue till 1969. Every time, 3 years extensions were given because it was needed. And then ultimately, when the Bangladesh war was coming on the horizon, then in 1971, the Maintenance of Internal Security Act, that is the MISA, was enacted in 1971. But during the emergency, 75 to 77, there was a lot of misuse of this MISA. And therefore, when Mrs. Gandhi lost the power, Janata Dal came, then this law was scrapped in 1978. There was a gap of 2 years, 78 to 80. 80 again, National Security Act was enacted, brought into place. Mrs. Gandhi came back. So, and after that, you have seen that after she came back, and then there were problems in so many other places, and therefore, about the UAPA Act, there is so much being said, and the people are saying that UAPA Act should be scrapped. I'm sorry, this is a very dangerous proposition and suggestion. UAPA Act must remain if you really want to fight the menace of terrorism. UAPA Act, first of all, I said, is not a detention law. It is a regular law under which the accused are arrested, and prosecuted, and after a trial, they are convicted. This was the law which was enacted in 1967 on the basis of the recommendations of the National Integration Council, because there used to be a lot of communal problems. So this law was enacted. There was a 16th Amendment in the Constitution, and in 1967 it came. But when all other laws like TADA was enacted in 1985, after Mrs. Gandhi's assassination, TADA was enacted. It under political pressure, it lapsed in 1995. Then 9/11 happened and POTA came. 9/11 happened in 2001, September 2001. And POTA came in next year, 2002. But again, because of the political pressure, it was scrapped in 2004. And therefore, to have some legal, some law, legal weapon in our hand, certain sections were inserted in UAPA Act in 2004. And that is the Chapter 4 of the UAPA Act, in which they have said that certain fundamental rights are suspended, like freedom to form association, freedom of speech and expression, etc., is suspended. And anyone, certain associations are declared unlawful. And if you become a member of that association, it's punishable. It is punishable. It is not a detention. Similarly, certain terrorist acts are defined. And if anyone is caught in that, he's put on a trial, and so it's not a detention law. And today that is the only anti-terror law. States like Maharashtra have their law like the MPDA Act, etc., which deal with the problem of gangsterism, organized crime, and all that. Let me tell you, I was police commissioner of Bombay in 2000 to 2002. I retired in 2003. And earlier I was joint commissioner in 93, when the Bombay blast case took place, in which 257 people died and 713 people were injured. Bombay has since then suffered 12 major terrorist attacks, in which 1,100 people have lost their lives. 1993, 257 people were killed. 2006, the train blast, in which 190 people were killed. And again, then 26/11, the attack on the Taj Hotel and Oberoi Hotel and elsewhere, in which 166 people were killed, including some 11 or 14 police officers. So this is the state of affairs. We don't have to fiddle with this kind of a this is the state of affairs, and we have to be mindful of this, and we have to be ready to face with this problem. I think with these things, I come to the end of my presentation, and I hope that I have been clear enough. And I thank Mr. Ribeiro and Mr. Raja once again for calling me. And bye. If there is any question, I'm willing to answer that.
Yes, sir. Indeed, thank you very much for your enlightening speech and your valuable opinions. Audience, now we are entering into the question and answer session. If there are any questions, please put them into the chat box. Due to paucity of the time, we may be able to take only a few questions. Shri M.N. Singh, sir, we have one question. Sir, you have worked extensively in the field of law and order in the era of 90s and may have seen various instances during the turbulent period of crime in Mumbai. So could you please share with us any live experience during your tenure as the joint CP or your tenure as an IPS officer?
Well, there are many. Let me tell you, the decades of 80s and 90s of the previous century were very, very bad. When the underworld was on the prowl, and they were killing people like they were killing flies in the streets. The streets of Bombay city were all soaked with blood. Right in front of the police commissioner's office on the pavement, a businessman was shot dead. And you know, the 92-93 riots happened, and in 93 March, 12th March, the serial bomb blast happened, in which I have said 257 people were killed. All the major iconic places like the Stock Exchange building, Air India building, 3 5-star hotels, and so many other places like that were attacked. Their plan was to kill so many leaders, and soon after that, in the month of March, 31st March, a BJP MLA Prem Kumar Sharma was killed by the gangsters. Then in the month of May, Ramesh More, Shiv Sena MLA, was killed in Santa Cruz. Then in August, Ramdas Naik, MLA from BJP and the president of Bombay BJP, was shot dead by the gangsters. And a year or two later, Datta Samant, the member of parliament, was killed by gangsters. A very big industrialist, Sunit Khatau of the Khatau textile mill, was shot dead in 1994. So the things were happening, and they were so dangerous. It was such a desperate situation. We had therefore to come down very heavily on them. And we had to use them again. When I came to Bombay City as the police commissioner in May 2000, let me tell you, more than 100 people had been killed by the terrorists in 1 year, in the year 1999. 100 people in 1 year being killed by terrorists, by the gangsters, organized criminal gangs. And so many people were under threat. Film people were attacked, some were killed, some were under threat. The film industry has given a notice to the government of Maharashtra that we are shifting to some other city because Bombay has become very unsafe. Bombay City was called the crime capital of India. This was the situation in Bombay City. When the underworld was ruling the roost, people felt very insecure, very unsafe. Lots of hoteliers, lot of builders were killed. Lot of film people were attacked and killed. Important industries were killed. So many MLAs and MPs were killed. And any number of other leaders were attacked. This was a very desperate situation. And therefore, when we started the action, we had only the ordinary law, but I had to use this MPDA Act, Detention Act. There were 600 cases, 600 people were detained under that law during my period. And all the cases were approved by the advisory committee. There were one or two few cases which were let off by the court because of technical flaws. As Raja said in his presentation, that in Aurangabad, when we had detained a person was let off because he did not know Hindi, English, he only knew Urdu. This is what he said, because he said he was a Muslim and he had not studied English, but he understood Hindi and all that. So on that technical ground, he was released. There used to be some such releases, and that also shows that the judiciary is very, very strict in these matters. And if there is even a small flaw which affects the right to defense of the detainee, then the court comes to his help. So it's not, so most of the people that we had detained, as I said, about 600, I don't have the exact number, about 600 people were detained under the MPDA Act. They were sent on, that was a preventive detention. They were sent for about a year. All cases were approved by the advisory board. There were very, very few cases which were let off by the court for some technical default. And these strong measures, they did help us control the problem of the organized crime and the underworld. And I can say with a certain sense of satisfaction, I have been retired for 18 years and the city is still free from the menace of the underworld. Now, there are certain cases that we investigated. I don't think there is time here to discuss those cases to make it a very interesting proposition. But there were many cases, like the blast case investigation itself is a case which has gone into the history because it is a case in which 80% fellows were convicted, despite the fact the trial lasted for 14 years. There were 600 interlocutory petitions. There were allegations made by these fellows even against the judge. There were allegations made against me. There were personal threats to me and to the judge. All that happened. But ultimately, after 14 years, out of 123 persons who were put on trial, 100 fellows were convicted. Of the 100 fellows, 12 were given death sentence and 19 were given life sentence. It works out to 80% conviction rate, which is a matter of great satisfaction and pride for anybody. So it is not that, you see, the police is incompetent or police cannot do the job, or the police do not understand these laws and all that. When there is a challenge, the police come respond very effectively. I think this needs the general appreciation by the public and by the judiciary. It needs a good certain support from the public at large, from the civil society. I think it is unfortunate that some of these cases which have happened in the recent times, which have been given too much of publicity and too much of criticism. I'm sorry to say that at times when we discuss these matters, there is a political overtones even in the debates, in the presentations made by experts. And I think when you are discussing something concerning law, something concerning judiciary, politics should be kept aside. To mention about the prime minister or the chief minister in such discussions, I think is highly deplorable. And I think the problem has to be sorted out by the police and the administration and the judiciary together. And even if there is a problem from the political side, I think if we three come together, the police, administration, and judiciary together, I think the political pressure can be very well understood. That's it. Anything else?
Yes, sir. Thank you very much. I would thank all the panelists present today who have shared their valuable opinions with us. And indeed, if I speak on behalf of all the law students, it was really an interesting session and a lot to learn from. Thank you, everybody. And
thank you.
Really, it was very, very interesting to have an interaction.
I thought you had disappeared. You had gone away, Mrs. Vaidya.
Ma'am, you're on mute.
Has she gone? I'm not able to see her.
No. Principal, ma'am, you're on mute.
Yes.
Yeah.
Are you able to hear me now?
I can, Mrs. Vaidya, I thought you had gone away. So.
No, sir, I am here. I'm listening to your discussion, everybody's discussion. I really enjoyed because you have unfolded many aspects of preventive detention, and practically you discussed many things. So we are really thankful to all the three panelists.
Thank you.
Particularly thank you to Pichawala sir, who is here, and he is senior most person amongst us. So I'm really thankful to all of you.
Thank you.
Thank you. Thank you. Thank you very much. Thank you.
Thank you. Thank you very much.
Thank you.
Very nice session.
Yes. Now
we can leave now.
Sir, just a minute. We have the now as we move towards the closing ceremony, I would like to hand over to you, Sushmita, to take ahead the closing ceremony.
So we have a tradition of closing the ceremony by national anthem.
Okay.
Just wait 2 minutes, sir. Just wait. Okay. So thank you, Tanay. I would like to invite Honorable J.F. Ribeiro, sir, to give the vote of thanks.
I think all of can we hear?
Yes, sir.
Okay, I think we have really discussed for 2.5 hours, and the young people must have definitely learned a lot. I'm happy that M.N. Singh came on this discussion because he gave a different perspective, especially from the police viewpoint. I do agree that preventive detention laws or even the UAPA Act may be necessary, is necessary, but it should not be misused, as Mr. Raja has so nicely put it. It is being misused. That is the problem. It is not that we are against the preventive detention laws. But there is one thing that I would like to point out to the young students here, that what M.N. Singh has tried to emphasize is about terrorism. Now, most of these laws are not being used against terrorists at all. That is the problem. Terrorism is quite different from underworld gangs. The underworld gangs don't put bullets to the police or through the authorities. They only bribe you. Whereas in terrorism, because I worked in Punjab in those days, they just put a bullet through you. There's no question of bribing the police or anything like that. So it is quite a different problem, and they do not accept the state. They do not accept the law. They accept nothing. And the terrorists are now, for example, this girl what is her first name? Ravi, Disha Ravi. Now, is she a terrorist? I mean, you can't really take her up under the UAP Act like they did, or sedition. This is ridiculous. And so it is highly misused. And that is what we have to ensure, that it is not misused. The sedition laws are misused. In fact, the Supreme Court, short of striking down the sedition laws, had given very good directions in the Kedarnath judgment. But where is it being accepted or implemented by the police? That is they don't do it. In fact, it has increased. The misuse of the law has increased so much after the Kedarnath judgment that the police should be ashamed of it. This is the fact. So there's a lot of scope for another debate between Mr. Gonsalves, Advocate Gonsalves, whom I've heard often and who speaks really well and will give you his side of what the people feel, especially those who are activists. It is this UAP Act being used against activists. And one more thing I would like to say, that look, there is a very strong suspicion that evidence has been planted. Now, that has been found by experts in Boston, in Massachusetts, and it has been, other experts have confirmed that it has been done like that. But what do we say? We say we don't accept experts from abroad. We only our experts. I mean, that I think is a clear negation of justice. If it has been planted, well, it is so, and people should not be taken. It is a very serious offense, according to me. So this is another problem that we have to consider. Anyway, so I thank all the panelists. I thank the students. I thank the Law College, its principal, Dr. Vaidya. I thank all the young people, the campus ambassadors, and my staff, our PCGT staff, not my staff, sorry. It is our Ruchi Bhagat who has taken such great pains to make this a success. And all our trustees who are present here, Professor Pitawala from the Law College. There are a lot of people who are present here and who are interested in this subject. And we have, I think the PCGT has done a good job in bringing this subject before the students. Thank you so much for attending. Yeah, now you can go with.
Thank you, sir. Thank you very much.
Yeah.
After a long time, we had a word with you, sir. We hear your words rather. So it was nice meeting you on screen. Thank you. Thank you very much.
Thank you, sir.
Thank you.
Now I would like to request you all to stand up in honor of the national anthem.
Yes.
I did.
You did?
Yeah.
Yeah.
So thank you all.
Thank you very much.
Yes, namaste.
Thank you, ma'am. Thank you so much.
Yeah,
Thank
Thank
you.
you.
Ruchi,
Thank you.
Raj,
Bye
all
bye.
the NSS, Tanay
Thank you.
Musale,
Thank you,
you did
Ruchi.
an
Thank you.
amazing
Bye
job.
bye.
Thank you very much.
Thank you.
Thank you, everyone.
Tanay.
Thank you.
Namaskar.
Thank you.
Namaskar. Singh sir, namaskar. Raja sir, namaskar.
Thank you. Thank you.
Always
Yes,
sir,
thank you.
namaskar.
And good
Yes.
night to all of you.
Yes, good night.
Good night, sir. Good night.
Special thanks to
Ma'am, sir,
Ruchi.
last minute photo.
Yes, Harshal, please.
Yes,
One
please go
photo.
on. Yes, please, please.
NSS volunteers, if possible, please put on your videos.
Ajay waits.
Yes, thank you.
Done.
Thank you, ma'am. Thank you, Kritika, ma'am. Thank you, principal, ma'am.
Yes, thank you and good night.
Thank you. Good night, ma'am.
Tanay, well done.
Thank
Well
you.
done.
Very much.
Yes.
Tanay, Ruchi, it was wonderful.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you to the NSS unit
Sushmita?
for stepping
Yes,
in
ma'am.
and helping us.
Yes, it was wonderful, dear.
Thank you. Thank you so much, ma'am.
Good night,
Okay, bye-bye
everyone.
to all. Bye-bye to all.
Bye, ma'am.
Bye, ma'am.
Tanay, Sushmita.
Ruchi, stop the live streaming now.
Oh.